Today we present a very special episode of Level Up Law as we look back at some of our episodes from 2021 that were particularly impactful or were shared across many platforms. The first video we'll look back on today was our most watched Level Up Law episode from 2021. In Eviction Defense 101, Mark Fessler walks us through the basics of eviction while also sharing our online legal classroom that helps people who are facing eviction walk through the legal process and understand it on their own.
Sort of the gist of what we're going to try to get into, which is our new residential eviction defense classroom, and hopefully y'all can already see sort of the landing page for that right there. Before we get into that, I've been asked to and wanted to give a plug for our low-income taxpayer clinic program. So, we always like to make you aware of everything that we're doing at South Carolina Legal Services. So if anybody has tax needs and they're a low-income taxpayer, maybe they're getting garnishments or whatnot from the IRS, you can apply to legal services, and we have a low-income housing tax clinic that can help address those needs. But let's turn now back to the classroom. So, in thinking about putting together legal information to put it out to the public, one thing we wanted to do is we wanted to provide information that was, more in-depth than what you might typically find when you just do a random Google search about evictions in South Carolina. And we also wanted to make the information specific to South Carolina law because, although every state has evictions and has laws, they differ from time to time, place to place. And so having something that is unique to South Carolina, specific to South Carolina, was important for us. And we also wanted to create a classroom that tried to answer some of the common questions we get and maybe resolve some of the common misconceptions that people have about, what a lease is or how eviction works and things like that. So as Susan said, this is sort of in development, and we're in our, let's call it a beta testing phase at this point. And so you're going to get a survey after this presentation. And if you would, it's just 3 questions, respond to that survey, and that'll help us with the feedback that we need to make the classroom better and to improve that classroom. And so what the classroom is, South Carolina Legal Services, we've already created a number of classrooms, and we host them on this website called lawhelp.org/SC. And you can see the classrooms that are already available for public consumption, from debt collection, guardianships, getting your landlord to make repairs. And when you click on a link to one of these classrooms, it'll take you to the same sort of landing page that we're going to go over for residential eviction defense. The only difference is the eviction defense classroom is not public, whereas if you wanted to learn about getting your landlord to make repairs, you can do so. So I just wanted to give you an idea of where that will be once it does get published on our Law Help website. So, the classroom starts off with an introduction. It talks about, we're going to talk to you about the basic steps that you can use if your landlord sues you for eviction. And it consists of individual lessons. They're formatted in an FAQ type setup. So, what laws apply, what are the reasons somebody can be evicted. And the classroom really assumes that you're at the beginning of the legal process. That disclaimer is important because we often get people coming to us who, have already been sued for eviction or who already may have had a hearing. And so, the classroom may not apply or all parts of the classroom may not apply to them. But if you are at the beginning of the legal process or seeking general legal information, you can start at the beginning. And so, we really start with the basics. What is an eviction? It's the legal process that a landlord uses to retake possession of a dwelling unit. And as you may have noticed from the getting your landlord to make repairs, there was a video appended, and we're going to have a video appended here. We don't have it uploaded to the system yet, of course, but we do have that video for you. So I wanted to show you sort of our world premiere of residential eviction defense, and you can respond to that as part of the survey. So once I play this, I think it'll mute everybody, and so enjoy.
An eviction is a lawsuit that a landlord must file to retake possession of an occupied residential rental unit. An eviction can be filed because your lease term has expired.
Our next featured video features a Level Up Law episode from 2020 that was replayed over 1,000 times in 2021. In Social Security overpayments, Public Benefits Unit Head Jenny Kaufman gives us an overview about what Social Security overpayments are, how they happened, as well as the process for appeals, asking for a waiver, getting a change to your repayment rate, or getting extra help with Medicare premiums. Again, this was our most rewatched video from 2020 that had a lot of replays in 2021.
A Social Security overpayment occurs when any time an individual receives more money than they were allowed to receive from the Social Security Administration in any given month. It can be something that occurred 2 or 3 years ago, or as recently as last month. But it's any time you get more money than you are supposed to. These are basic rules about what you should do whenever you are dealing with Social Security. Remember, they are a very large agency and mistakes get made because they are understaffed. So you need to keep proof of what you file, make copies of everything you send them, and please make sure there is a date on any document you send them. We often forget to put that date on there, and it's critical so that it can remind you of when you sent it in to Social Security. There are online appeals and the ability to file documents. So if you do deal with Social Security online, make sure you print the receipt that it gives you at the end. If you don't have a printer at home, take a picture of your computer screen. Either the computer itself can take the picture, or you can take one with your phone. Anything you can do to capture what it was that you filed online. If you mail something to Social Security, please go into the post office and get proof of mailing. Or better yet, if you can afford it, send it certified mail, return receipt requested. That way you have proof that it was mailed and received. You need to remember, if you do not have proof you did something, it's going to be harder to argue with Social Security that you sent it. It's the biggest mistake that I see people making, is not having proof that they actually took something or mailed something to Social Security. Now, there's a number of different reasons that overpayments occur. And you have to remember there are 2 basic programs in Social Security. One is the Retirement Survivors and Disability Insurance Program, and the other one is SSI. For SSDI and retirement, the major reasons for overpayments to occur is the failure to report work activity. So anytime you go to work before your normal retirement age, you are supposed to be reporting your work activity. If you receive workers' compensation benefits, Social Security needs to know about that. The receipt of certain government pensions will reduce your Social Security retirement benefits, and so you have to report those. For most people, those government pensions are going away and being replaced by 401ks, but if you still are eligible to receive a government pension based on work activity alone, you need to tell Social Security about that. When a dependent lives in a different household, becomes eligible for benefits, it can make your benefits go down and result in an overpayment. marriage or divorce, changes the amount of benefits a person may be entitled to receive. In this, for SSDI, if Social Security reviews your case and finds medical improvement, that can result in an overpayment.
Our next featured episode was our most shared episode on social media from 2021. In special programs for special kids, Lanier Sims and Mary Lou Seymour walk us through public education programs provided for students with special needs.
One of the first things I always tell people in these education cases or dealing with the special education things is that parent participation in the process is crucial. These school districts and school officials and personnel, their job is, to follow the letter of the law and to provide services for the kids, but they can only provide the services the child needs if they have all of the information they need. And one of the best places for them to get that information is from the parents. And also, I tell people that their expectation is crucial, because going into these processes, sometimes parents don't know what to expect. And so hopefully after today, they'll have a better idea of what they're going into, what they should expect from the school district, or from any of these things that we talk about here today. This is going to be important as we talk about all the education things today. You'll hear me say idea repeatedly and probably too many times throughout today's webinar. And so just before I start throwing out acronyms that no one understands, IDEA refers to the Individuals with Disabilities Education Act, which is the federal law that requires public schools, i.e. any schools receiving federal funds, to provide a free, appropriate public education, or FAPE, to eligible students with disabilities. As of the 2018 to 2019 school year, IDEA was applying to and responsible for providing services and early intervention services to over 7.5 million students within the United States. So this is not something that's not prevalent everywhere and that doesn't have a lot of kids receiving services under it. You'll hear me talk about two different parts of IDEA, which are Part C and Part B. Part C applies to those children from birth to 36 months and their families, which is important, and we'll discuss that a little more in a second. And then Part B applies to those children and youth from after they age out of Part C at 36 months until they're 21. And again, it applies to all schools receiving federal funds or public schools.
Our next Level Up Law 2021 highlight involves our most attended Level Up Law webinar. In this episode, Mark Fessler with Legal Services, SC Stay Plus, and Guidehouse discuss some changes and an extension of the COVID-19 Eviction Moratorium, as well as some options that were available for rental assistance for people who may have been struggling with eviction or other rental issues during this time period.
CDC newly extending their eviction moratorium, we thought we'd tie that in with an overview of rental assistance and specifically how that works through the SC State Plus program. So I'm just going to talk about what the new eviction moratorium, which lasts maybe until October 3rd, 2021, says and what it can do for our clients and other tenants. So the new moratorium was issued on August 3rd, 2021. And the goal is really the same as the old. It's to suppress the spread of COVID-19 by preventing evicted persons from becoming homeless or because they might be or have to move in with others in shelters or with family or friends. There's research that I don't go into here, but that the CDC's order discusses that talks about how individuals who become homeless or have to move into what are called congregate settings, meaning living with other people, are more likely to spread and to receive the COVID-19 virus. So the order specifically prohibits a landlord or any owner or other person with a legal right to pursue eviction from evicting a covered person. We'll talk about what a covered person is in a later slide. They cannot evict that covered person from any residential, so it doesn't apply to commercial, but residential property, while COVID-19 transmission in the particular state, county, or locality is substantial or high. Substantial and high transmission rates are technical terms that are defined by the CDC, and we'll review a resource that the CDC has where you can go and you can click on a map and see whether your county is color-coded substantial or high. So what does a covered person mean? In previous versions of the CDC's order, there were 5 different things that a covered person had to attest to be a covered person. 1, that he or she was using best efforts to obtain all available governmental assistance for rent or housing. So that's kind of a tie-in to what we're talking about next with the SC Stay Plus. You have to show that you're trying to get rental assistance from all available governmental sources. 2, you have to attest that you either earned no more than $99,000 if you're a single person, or $198,000 if you file jointly in 2020, or the same for 2021. You expect not to earn more than that. Or you can attest that you were not required to report income, or that you received an economic impact payment, a stimulus check. You also have to report that you were unable to pay rent due to a substantial loss of household income, or a loss of work hours, or a layoff, or an extraordinary out-of-pocket medical expense. An extraordinary medical expense is defined for the purposes of this order as an expense or expenses that are more than 7.5% of somebody's annual gross income. You'll note there that the hardship, the financial hardship, doesn't have to be COVID related. It just has to be the substantial loss of household income for any reason. You also have to attest that you're making best efforts to pay what you can, to make partial payments or as close to the full rent amount as possible when taking into account your other non-discretionary expenses. So that's things like food, utilities. If you don't have any money to put towards rent, it's not required that you pay, anything really if you don't have non-discretionary income. But if you do, you're supposed to make best efforts to make partial payments. And you also have to assert that if you were evicted, you would likely become homeless, or you would have to move in and live with other people. So the new order has the same criteria for a covered person, but it adds the criteria that the individual has to reside in a U.S. county that is experiencing substantial or high rates of community transmission, or high rates of transmissions of COVID-19.
For our last featured episode, we asked Level Up Law producers Susan Ingalls and Kenneth Elliott to choose a producer's choice to recognize from 2021. They chose Guardianship and Conservatorship by Jessica Schultz. They felt like this was a good episode to feature because Jessica used extra outside resources and was able to break the information down in a very easy to follow way.
Start with definitions in guardianship and conservatorship law. Guardianship and conservatorships are part of the probate code, and that's found in Title 62, Article 5. And this is Section 101 talking about definitions. So typically, guardianships and conservatorships come up when someone is concerned about an individual, maybe a family member, who is unable or seems unable to make their own healthcare decisions, or unable to make their own financial decisions or otherwise. So that person that we're concerned about is the alleged incapacitated individual, and that's also known as the AII. This is the adult who is the subject of the guardianship or conservatorship action. So guardian and conservator, they are two different fiduciary roles. They each take care of the different aspects of the AII's well-being. The guardian is the person appointed by the court who makes decisions regarding a ward's health, education, maintenance, and support. And note that at the point a guardian is appointed for someone, they are no longer an AII, but they are now called a ward. And that is the adult for whom a guardian has been appointed. A conservator, so the guardian takes care of someone's medical well-being, A conservator takes care of their financial well-being. So that's a person appointed by the court to manage the assets of the protected person. And this can be an incapacitated individual, a minor, or a person in need of a special needs trust. Note that similar to how a ward is appointed a guardian, a protected person is appointed a conservator. So it is just a little bit of a definition distinction right there. I know this question was asked previously, whether or not South Carolina does recognize guardianships for minors, and we do not. The probate court does not have jurisdiction to appoint a guardian over a minor, and that does have to be done through family court. However, conservators can be appointed for minors. This is usually seen when a minor inherits an interest in real property. They're actually mandated to be appointed when a minor receives assets that are valued over $15,000. So that's just, it's good to keep in mind that which some guardians can only be adults. Conservatorships can be any age. What is capacity? This is the million-dollar question. And we actually don't get a definition for capacity in Article 5. So what I've taken right here, this is the definition of incapacity, and I've just inversed it. We'll get to incapacity in the next slide. But basically, capacity is the ability to effectively receive, evaluate, and respond to information to make and communicate decisions such that a person can meet the essential requirements for their physical health and safety and manage their property or financial affairs, or provide for their support or for the support of their legal dependents with and without support and assistance. So I really want to focus on those keywords, support and assistance. So that includes estate planning documents that this individual might have executed earlier in their life. That can be a trust, a durable power of attorney, a power of attorney, or a living will. Support and assistance can include technology and devices, including devices that allow the AI to communicate better or understand better. That could even be something as simple as a hearing aid. Receiving assistance with communication, having additional time and focused discussion to process information, providing tailored information oriented to the comprehension level of the AI. Sometimes these individuals might just need a little more thorough understanding of what's going on. Oftentimes us attorneys learn to speak in legalese, and we have to be really aware of providing the information that we know and communicating it to individuals who don't have law degrees in a way they can understand. So kind of a similar thing. And then finally, assessing services from community organizations and government agencies. I'll talk about ABLE South Carolina in a few slides, but they are a community organization that does assist individuals in making these decisions for themselves on their own without a guardian and conservator.
Thank you for joining us in this Level Up Law 2021 Year in Review episode. Make sure to subscribe to our YouTube channel to see these episodes, more episodes, and upcoming episodes of Level Up Law. We also post other video resources and links to outside resources on our YouTube channel. So make sure to visit our YouTube page and subscribe to have access to all of these resources.